data privacy as a knife that peeled the onion to its core. That looks like an intriguing title. So I hope we will not all start crying when she starts peeling, but you have the floor.
Thank you very much, Serge. I apologize because I might have to leave this panel a little bit early because we have the EDPL board meeting that I'm skipping right now. So there is a conflict of obligation. So yeah, I wrote this paper on essence of fundamental rights. And it is already published on SSRN, but now a very, very modified version of it has been submitted to the European Constitutional Law Review, and I'm just waiting for the final decision of that journal, whether it will be published there. So fingers crossed. So I'll talk a little bit first about the background of the essence. So the essence is a concept that has been included into Article 52, paragraph 1 of the Charter. This is a concept that previously in this form did not exist in the European legal order, but nowadays Article 52, paragraph 1 states that any limitation of the rights recognized by this Charter must be provided for by law and respect the essence of those rights and freedoms. And note when I read this article that the first part, the first sentence mentions the essence, whereas the second sentence mentions the principle of proportionality. Limitations may be made only if they are necessary and genuinely meet objectives of general interest. So this is kind of the core theme that we go throughout my presentation, is the distinction between, on one hand, the essence, and on the other hand, the principle of proportionality, and the methodology with which we determine the breach of essence. So this is how I see a fundamental right. And this is not a real onion, thanks God, so we will not start crying. But I see the outer border of fundamental right as its a part where the fundamental right is still whole, where it's still not breached. And then as we peel the onion more and more towards its core, we can see that there is an unjustified restriction in there, that there is an unjustified, particularly serious restriction, that before that was a justified restriction. And when we peel the onion to the end, we see that at the core, there is what I call the essence of the rights. So if we look into the constitutional origins of essence, what I argue in my paper is that there are three origins of this concept, how the concept found a way into Article 52. The first one is member states' law. And I argue that it could potentially be said that those legal orders and the notion of essence from those legal orders constitutes a common constitutional principle common to the member states, which is then on the level of the European Union law, a general principle of law. The concept first arose in German constitutional law, the Wesensgehalt, and somehow comically you can see in the German literature stating that this is the most successful export good of the German constitution, which has then been taken over by Spanish, Portuguese, Austrian, Hungarian, Polish, Romanian legal system. Then, secondly, the notion of essence can be also found in the case law of the European Court of Human Rights, which I must admit doesn't always systematically use the notion of essence as being distinct from principle of proportionality, and I will get later on a little bit into that as well. And then probably the most logic way of seeing how the essence found its way into the Charter is the older case law of the Court of Justice, where the Court of Justice talked about prohibition of infringing the very substance of the right. And this very substance then became an essence into the text of the Charter. So it is very interesting to see how constitutional law somehow responds to the technological challenges and how technological challenges can actually shape the outcomes from the perspective of constitutional law. So when we look at the cases which deal with metadata, such as case Digital Rights Ireland or Tele2 Sverige, then we see that the court does not come to the conclusion that there is a breach of essence of fundamental rights, but to the conclusion that there is a particularly serious breach. However, when we go a step further, the access to the content data, such as in Schrem's case, and the mass surveillance, this is where the court concludes that there is a breach of essence of two fundamental rights. On one hand, the right to effective judicial protection, and on the other hand, the right to privacy. Now, from a perspective of technology, these conclusions of the Court of Justice don't make much sense, because we know that also from metadata we can infer a lot of personal information, sometimes even more than from content data. But from a constitutional law perspective, it is very significant to have these two notions distinct. So what I argue in my paper is that every fundamental right has an untouchable core that cannot be restrained and that cannot be infringed unless if that fundamental right stopped existing. And there are two different theories, especially in German literature, which are sort of battling between each other. And one theory states that essence is indeed an independent concept, and the other theory states that, well, essence is just an extension of proportionality. And essence shouldn't be considered as an independent legal concept, because we can come to the same conclusion even if we say that a restriction has been disproportionate. It is very close to human dignity. If you look into Article 1 of the Charter and explanations to Article 1 of the Charter, you will see that human dignity is actually part of every single fundamental right. So it can also be claimed that every breach of essence of fundamental right is in the same time breach of human dignity. I will not go here into the discussion whether that would be a breach of constitutional right, Article 1, or whether that would be a breach of constitutional value, which dignity can also represent, but I can address that in questions. So what I argue is that in order to ensure that essence remains an independent concept, as it was recognized also in the case law of the Court of Justice, we need to have a different methodology to establish whether there was a breach of essence and not proportionality. So I have mentioned already, well, one approach to treat the interplay between proportionality of essence is this relative approach. And the relative approach has been adopted mainly by the European Court of Justice in its case law, where the Court of Justice, European Court of Human Rights, where the European Court of Human Rights states that limitations should not impair the essence of the right, and they should pursue legitimate aim. So we can see that the Court of Human Rights confounds proportionality with the essence. The exclusionary or absolute approach, this is what I argue it should be adopted in the framework of the European Union law, claims that proportionality cannot be applied if essence is found, or maybe even better to turn this around, that proportionality cannot be used as a methodology in order to find a breach of essence. That can be seen from the textual interpretation of Article 51, paragraph 1, 52, paragraph 1. This is what I mentioned at the beginning, distance in two sentences, and also from the perspective of the fact that Court of Justice really recognized this notion of essence in its case law. And now the question that can be asked is, what kind of approach does court use in Schrems? I argue that with regard to the breach of essence of the fundamental right to judicial protection, the court uses this exclusionary approach, absolute approach, because it doesn't use proportionality in order to establish the breach of essence. And what it said, the court says that there is no possibility whatsoever to challenge the breach of fundamental right, and because of this absolute absence of the possibility to challenge a breach, there is a breach of essence. When it comes to the breach of essence of the right to privacy, the court is very confusing, because it comes to the conclusion that there is a breach of essence, but then it still applies the necessity test of the proportionality. The problem with that, and the reason for that, is, in my view, not sort of a noble constitutional rationale, but the fact that the court wanted to avoid the identification of the legitimate aim. So the first step, the step actually that comes before the principle of proportionality. The overriding reasons in public interest, in that case, if the court would have really applied the law as it should, would be the protection of national security. But which national security? The national security of the US. And I believe that the court didn't want to go into the balancing of US national security with the European right to privacy, and then it just jumped over this step and concluded that there is a breach of essence. Now, just coming to my last slide, the methodology that I propose that the European Union law and the European Court of Justice should use when they determine whether there is a breach of essence is to determine whether the interference calls into question the existence of the fundamental right. And the existence of fundamental right can be called into question either for a particular right holder or for a certain group of right holders. And you can see that in the more recent case law of the Court of Justice on essence, is that Court of Justice very often says there is no breach of essence because this limitation does not call into question the right as such, so its existence. And this, I propose this to be sort of the first step of the test. The second step of the test is to identify whether overriding reasons exist or not. If overriding reasons exist, and if they are legitimate, then I believe we should follow the proportionality path, which would make the breach of essence a very rare conclusion. It's something which is really reserved for the most blatant conclusions which have absolutely no justification. So I believe that if we apply that to Schrems, the effective judicial protection would have passed this test, but in the question of limitation of the rights of privacy, the overriding reasons existed, and that's why I believe the court should have taken another avenue and not decide that there was a breach of essence of privacy. Thank you very much for your attention, and I'm very happy to answer any questions.
Thank you very much for this very beautiful presentation on a very complex issue, and I see that there is a first question already.
Thank you very much, Maya. I am very fan of your paper, and I'm very glad to see you in person. I have a question in the Schrems case, because you speak of the essence of privacy. You speak of the essence of data protection, but I think that in Schrems they speak about the essence of privacy. So my question is how to distinguish the essence of data protection from the essence of privacy, because it's a great, we have a great text with a charter, and we have this Article 16 from the treaty, but usually the court, I agree with you, it doesn't help because there is no real distinction between both rights. So I want to have your opinion on that.
Yeah, thank you very much. That's a very pertinent question, and I apologize if I wasn't precise enough in my presentation. I have written elsewhere also on the distinction between privacy and data protection, and the conclusion to which I came is that they are partially overlapping and partially not. Now, in order to determine when they are partially overlapping or not, you need a concrete case. I think that there are cases where you can say that there is an infringement of privacy and data protection, and most of the cases will be like that. But there are some cases where you can also not say that. Now, the distinction on essence, it depends on the scope of application. If the scope of application is covered one with each other, then the same infringement can actually constitute infringement of essence of both. If their scope of applications are separate, then you would need to look for separate infringements of essence. Yeah, thank you.
Here is another one.
I'm pretty much intrigued by your presentation. Still, I have like a big question mark, which is probably a result of my background. I do specialize in human rights protection and employment. I was just thinking how, like, what do you think whether it's therefore possible to extract like one universal essence of right to privacy or right to data protection, or whether it's going to be much more context dependent? And this would be my guess, knowing the case law on the right to data protection and right to privacy in employment, which I would say the essence as such would rest upon, for example, the right to establish a relationship with other human beings. Would it be the same in other contexts, or what do you think about it?
Yeah, that's again an excellent question. Thank you very much. Just do it because it's better like this. So you're absolutely right that the essence and breach of essence is always context depending. There is not one essence. There's always several possible breaches of essence of one same fundamental right. Like, for example, if you have the right to marry, then I believe that it would be an infringement of essence if you say that women can only marry up until the age of 20. That would be, for me, quite a blatant breach of essence of fundamental right. But you can also breach the essence of fundamental right by completely prohibiting the possibility to marry, or prohibiting the possibility to marry only for women who are not virgins anymore, or things like that. So you have very different measures. You have very different possibilities of how an essence can be infringed. And looking back into where the concept of essence comes from, and that's from the post-war Nazi Germany, the concept of essence was introduced into German constitution in order to prevent the atrocities, to repeat the atrocities of the Second World War, and to actually prevent that a government like a Nazi government would do away with fundamental rights and would completely strip people from their fundamental rights. So I absolutely agree with you that you should have a context in which you decide, and you cannot do that in an abstract level.
Yes. So thank you very much for the presentation. It was really nice. I really like the part where you said about, I don't know which judgment, that this doesn't make any sense from a privacy perspective, but it makes sense from a constitutional perspective. I think you were saying what the court says about the essence of privacy data protection doesn't make sense from a privacy perspective. And I don't know which judgment you were commenting, but I think you could say this about all the judgments. Every time that the court has been using this essence in relation to privacy or data protection, it never makes any sense. Like the court, the opinion on the PNR, it doesn't make sense. You try to figure out why would this be. So when you start saying the core, the essence is about data security, data protection is not about data security, this is why we have data protection. So if it does not make sense from a privacy perspective, what's the point? I understand it's interesting from a constitutional, theoretical, academic perspective, but is it going to save us? Is it going to help from a privacy perspective?
Yeah, I would say that privacy is quite a contested field when it comes to essence, because it's also the first field where the court recognized the breach of essence. But if you look a bit further into the case law, there are also cases in other areas where the court either decides that there was a breach of essence or there wasn't. I would need to look now exactly into the paper which areas are those. And there it seems to me it makes a little bit more sense. What I have a feeling with privacy is that the court is a little bit confused as to what exactly the breach of privacy entails, and that you can see that very much with this, distinction between metadata and content data, which absolutely doesn't make sense. That one breach would be a bigger breach than the other breach, and that also shows sort of maybe lack of expertise at the court from a technology perspective, which is definitely necessary if you need to decide privacy cases. Thanks, Gloria.
Then I have a question myself. I think that the notion of essence is strongly related to what I would call a substantive basis for human rights. And that is very German, actually. It's dignity. But how can you imagine the violation of the essence if all human rights are deemed to protect liberty?
Thank you very much for giving me the chance to elaborating on this point. Because what I argue in my paper is that breach of essence does not amount to the violation of the fundamental right to dignity, Article 1 of the Charter. as a constitutional right, but it is sort of an infringement of a dignity as a constitutional value. So in that sense, I do the distinction that Barak actually makes in his book, that dignity as a constitutional value is underpinning every fundamental rights, but it does not necessarily mean that we need to have certain measures or enforcements, but that, you know, we do take into account the fundamental right as a whole together with its root. And that breaching the essence is sort of de-rooting, like taking a tree out of the soil completely with its roots. So it's a very important point that you raised.
Thank you very much.
Thank you.
I would say I am more tempted to say that dignity is the product of human rights law in action.
You can also see it that way, yes.
But that's the opposite stance, indeed.
Yes, yes,
Okay.
interesting.
Okay, thank you very much. I think it's time to proceed to the next speakers, and the next speakers are Hugo Sant Ana Pereira and Carolin Moeller, and they speak in absence of Douwe Korff, but they speak also for him. Both are linked to Optimity, yes, advisors, and Douwe Korff is linked. Is linked to the London Metropolitan University. So you have the floor, 15 minutes. I don't.
Start this?
Thank you. We're just trying to put the presentation.
It's all in Dutch.
Yes.
Okay, brilliant. Well, hi everyone. Carolin and I are here in representation of Optimity advisors, as it was just said, to talk to you about a recent paper that we published on the use of algorithms and algorithmic decision-making in the context of law enforcement, and specifically a case study on fundamental rights infringements in the context of the PNR Directive. And also, as it was mentioned, we wrote this paper with Professor Douwe Korff, who unfortunately cannot be here today, but I guess many of you would recognize him from his great footprint in human rights and data protection space and his collaboration with many EU institutions, namely DG Internal Market. So we will start, is this working? Yeah. We'll start by giving you some background on the topic of algorithms and some definitions. We'll also give you a background on who we are. And then we'll move on to talk about the general EU legal framework on algorithms and the use of algorithms in the context of law enforcement. And then we'll actually talk about the case study of human rights infringements in the case of the PNR Directive. So a little bit about us. We are a global advisory firm which leverages research, analytics and design thinking to drive strategy and to deliver results for our clients, which are in the government and commercial sectors. Specifically, we have quite a big footprint in delivering work for the EU institutions from a research and evaluation perspective, namely on the topics that are listed there, such as consumer protection, information and data protection, and cybersecurity issues. And some of the studies that we've concluded recently for these institutions have been an assessment of the impact of using digital tools for cross-border company law operations for DG Just, an evaluation of the legislation of hacking by law enforcement, and so on. So to go back to the question of whether algorithms and algorithmic decision-making is the future of law enforcement, we want to start with a few basic definitions, although most of you will be familiar with this topic. So algorithms are procedures which take an input or set of inputs, process it, and deliver an output. This is their most simplistic definition. Surely algorithms can be much more complex than this. They can be self-learning, they can be machine learning based, they can be numerical continuation algorithms, they can make use of very advanced statistical packages, which makes their classification landscape quite varied. They can also be classified as the type of decision support they provide. So they can be decision-making algorithms, they can be decision support algorithms, and so on. But the bottom line, and what we want to draw from this, is that they govern many aspects of our daily lives, from the regulation of the metro traffic to air traffic control to Netflix preferences to social media news feeds. And in the law enforcement context, algorithms and decision-making algorithms have been used more and more in fields such as predictive policing and data-driven crime identification. A few examples of this, although it's quite disseminated at a global scale, include in the UK the Durham police force using a harm risk assessment tool in order to classify the risk of people who are arrested to commit the same crimes again. Vancouver has recently become one of the first regions in Canada to use data-driven policing mechanisms in the form of a home break-in prevention system, which had a great level of granularity in the type of data it could analyze, like neighborhood by neighborhood, and managed to reduce crime rates in the context of home break-ins by 21% in some neighborhoods. And of course, the recent ProPublica review, which I would highly recommend, which talks about data-driven crime reincidence prediction systems in the US, and specifically how some of them have developed ethnic bias. So it is also worth reflecting before we move on to outline some of the risks of using algorithms in these contexts, and then the case study on the PNR Directive, how this came to be. So the increasing availability of data has made a certain shift possible, and that shift is from a targeted to mass surveillance. This shift in itself was, we have identified 5 aspects in the paper which we think have facilitated also this shift. Some of these include the fact that we all have much bigger digital footprints nowadays. We all generate much more data. Also, there can be spillover of data. That is, data generated in a banking context can be used for surveillance in other contexts, such as law enforcement. And also, we've been seeing more and more the involvement of the private sector and synergies with the government on data surveillance. So I will now pass on to Carolin, who will talk about the risks of using algorithms in this context, and also the PNR case study. So go ahead.
Right. So as my colleague Hugo just explained, with this massive increase of personal data that is available from all types of sources and in all different types of contexts, that has obviously created the opportunity to use different tools to actually analyze this data. So particularly algorithms have been used not only in law enforcement but in different types of circumstances to actually make to have actually more efficient and effective outcomes, and also to actually make, particularly in law enforcement again, to make links available or visible where they have not been visible beforehand. So for example, in the past, if law enforcement agents would analyze criminal networks, for example in traffic trafficking, that would actually they would need a lot of time for doing that. But with the invention of algorithms, or with the use of algorithms, that can actually lead to much more efficient outcomes and detect, for example, links in this network that weren't visible beforehand. And then also algorithms could potentially prevent human biases, obviously dependent on the data that they are based on. So obviously that sounds already positive, but there are obviously a lot of and also serious concerns related to the use of algorithms. First and foremost, it's a non-transparent way to actually take decisions, because the algorithms are based sometimes on intransparent data, and also it's not always clear how they come to decisions, particularly if we look at self-learning algorithms that basically learn how to do things themselves without really the human input. Then the other problem is discrimination, particularly if algorithms take choices or take decisions that would discriminate against race or against gender, for example. And there has, for example, been a case where algorithms are discriminating because they're fed with data that was actually biased. So it always depends on the data that you feed the algorithms with. Then there's also something called the base rate fallacy, which means nothing else than that there's always a certain rate of error in the choices that algorithms take. And this is actually something that also applies to human decision making, but obviously the scale could be much higher if an algorithm takes massive amounts of decisions that are basically false. And then ultimately there's also a lack of accountability, because especially with self-learning algorithms, it's not really clear who's actually at the end accountable and also responsible, because at the end, is it the software developer, is it the human who analyzes at the end the decision, or it is actually not clear what is actually the accountability. And then why we're seeing all of this risk is particularly concerning in the law enforcement context, because that could have adverse legal consequences for individuals. They could, for example, be suspected of a crime that they have maybe not carried out, or they could even be on trial. So that is actually, using algorithms there is even much more sensitive than in all other areas. So having analyzed a bit the risks that are related to algorithms, it's also necessary to look into the legal framework. So first of all, the general EU legal framework does not really account for algorithmic decision-making, or at least there is a piecemeal approach to it. So there are certain initiatives, for example, on regulating algorithms in the context of online platforms or in the context of financial markets, and there's also something in the GDPR, but there's not like one single legislative on algorithms. In the law enforcement context, the main piece is the directive on data protection in law enforcement and in the justice sector, which has been recently adopted. And there, basically, the directive doesn't refer to algorithmic decision-making, but processing of personal data by automated means, which we treat similar in this context. And the legislator in this piece of legislation have actually accounted for the risks by introducing certain provisions on algorithmic decision-making. So, for example, they have explicitly pointed out that processing by automated means actually falls under the directive in order to avoid a legal loophole. Then also by default, Article 11 stipulates that decision-making based solely by automated means is prohibited. And then only if certain safeguards are provided for, member states can actually introduce some sort of automated decision-making. And then ultimately, anything that relates to profiling should also be prohibited and can only be done if it's actually, if there are special safeguards included. So now moving on to our case study that we presented in the paper, so algorithms and the PNR Directive. So first of all, to give a bit of a background on the PNR Directive, so it was adopted in 2016, but actually it has been discussed way before that on the EU level. So it actually all started already after 9/11, because that's when the US first initiated this whole debate about passenger name records, and based on that there was an agreement between the EU and the US, and that's when the Commission noticed that the EU shouldn't only react to initiative by others, but maybe also set up their own regime. But that was always somehow prevented because there was a lot of opposition, obviously, because of the fundamental rights implications it could have. And that's why it never really came into force. And then there was also the problem with the Lisbon Treaty, because there was a proposal that then ceased to exist because of the Lisbon Treaty. So again, the opportunity wasn't taken. And then only in 2016, when there was the Paris attacks, where actually a lot of the offenders involved in that have traveled to Syria to get some training, terrorist training, that was actually the trigger that made legislator adopt this piece of legislation. And basically what the PNR Directive stipulates, it's basically to require airline companies to collect all personal data from their travelers, such as their address, their name, also the amount of luggage that they take, the credit card details, and so on and so forth, and basically forward them to so-called passenger information units, or PIUs. And in these units, this data will then be cross-checked against certain databases in order to see if there's a match with, for example, an individual having been involved in serious crime or terrorism. And then this would be forwarded to the responsible authorities. And this is basically a massive intrusion in the rights of individuals, because obviously everyone is basically under this regime, and not only if someone is actually suspected of a crime. And that's also why it has been challenged several times by a lot of fundamental rights advocates, but also by, for example, the European Parliament members. So in regard to algorithmic decision-making, how basically the directive has some safeguards on that. For example, it says that the predetermined criteria which shall be used to actually check this data against the databases shall be targeted, proportionate, specific, and non-discriminatory. Also, every time there is a positive match with these databases, there needs to be a review by a non-automated means. And then ultimately the predetermined criteria shall be regularly reviewed. So obviously there are some safeguards, and legislators have noticed that there could be some concerns with that. But obviously there are still a lot of concerns that remain with that. And this was also noticed in the opinion of the Court of Justice on the PNR agreement with Canada, or this draft PNR agreement. So first of all, the data is not based on verified personal data. Then predetermined criteria are not really transparent and can vary across member states. Also, it's not really clear whether there are assumptions. So for example, is it intelligence that could be used to cross-check this data against? And then also there's nowhere a guarantee that the data that PNR data is cross-checked against is actually secure and reliable. So that leads us actually to our conclusions. So obviously we think there could be a case for revising the PNR Directive based on the concerns that I just mentioned. Particularly there should be some more clarity on what actually predetermined criteria are. Also there should be an independent body actually reviewing this predetermined criteria rather than the POIs themselves to potentially avoid the risk of profiling. And then also the databases against which PNR data is cross-checked with shall actually satisfy high security standards. And then just one final thought, we think that this is not only a topic that relates to the law enforcement sector, but affects every part of the society nowadays. And therefore there should be like a collaborative effort between academia, regulators, industry, and the civil society to come up with a framework on algorithms and ensuring that they are of high standards, that they are accountable and transparent, and most importantly, that they comply with the Charter of Fundamental Rights. Thank you.
Thank you very much. No? Questions? Question time. Well, oh, okay.
I would actually have a question. Yeah. Well, I would have two questions. The first one is on the Article 11 of the directive, which actually prohibits automated decision-making which has a significant effect on a person, and that would prevent also the automated decision-making such as the one within the PNR, but the algorithmic decision-making is now so widespread that we cannot prohibit it anymore. So that leads me to that's more a comment, that leads me to my question, is you said that any decision based on the algorithms is reviewed by a person in the PNR context. What exactly is being done? How does this person review this? Does it just rubber stamp? Does it go through the file? What kind of guarantees does that give us? Thank you.
Oh, yes.
So not all member states have implemented that yet, so there is not really a specific clarity on actually what is done in specific. But I guess what it basically means is that as soon as there is actually like a link, or there is some like alert popping up saying that this person has appeared, for example, in another database, or let's say the credit card that was used by this individual has also been used by a suspect of terrorism in another travel, and maybe it was even a similar travel pattern, that would mean that the individual has actually to go back to the passenger information unit officer will have to go back into the data, cross-check it all, and see whether that is actually confirmed. And then in a second step, as far as I understand it, that will be forwarded to the relevant authority in the member state to then basically understand whether action should be taken. So for example, should this individual be actually cross-checked more closely at the border, or shall actually the travel be prevented? So that's my understanding of how it works.
More questions? Then I have a question. According to more classical criminal law, actually, which is severe law, it protects people against the state that is inquiring them, is willing to punish them. In order to set up an investigation or to unlaunch the criminal law mechanism, you need reasonable suspicions. You need concrete indications of guilt. Now, my question is, isn't there a danger if we leave this decision to algorithms? It's not really a danger for data protection, but a danger for protections against the criminal law system.
Well, I completely agree with this point, and I think if you look into, I mean, the legislator tried to integrate some safeguards. So, for example, that it should be always reviewed by a human element. But if you take it one step back, at the end of the day, the algorithm makes the pre-selection. So, obviously, there could be also some fault in that. And yeah, I mean, I just agree with this point that there is actually a real danger to leave that to the algorithms. At the same time, probably law enforcement agencies would argue we have to keep pace because also criminals make use of the new technologies. They try to escape this, and they kind of have to adapt also to the modern environment. So I think there is a really big dialogue between these two positions, and sometimes it's not easy to draw the line and see what is still proportionate and what not. But I think in our paper we make the case that there are serious concerns, and particularly there's just a lot of safeguards missing, particularly the independent review by, for example, it could be the DPAs, it could be also another body that just looks into algorithms. I think that's something that is really important and should be integrated on a more wider scale.
I wonder what that would, well, maybe there are, okay. Come here and I will ask you. I wonder what that would mean for the grand jury in the United States.
Yeah, hello. You mentioned that one of the dangers you see with algorithmic decision making is that it's not transparent and that we might not be able to fully understand how an algorithm reached a decision. And that therefore it's necessary to have another human element. But do we understand human decision making sufficiently clearly to actually render that a better choice than an algorithmic decision making?
That's a very tough one.
Well, I completely agree, and actually that in the one slide I said that there's this base rate fallacy, which means that algorithms, they can actually also always take wrong decisions, right? And the same accounts for humans. Probably, I mean, what they could just try to do is a cross-check, because at the end of the day, you can have a faulty algorithm, you can have a faulty human decision. That's obviously also clear. I think what makes the difference on why there is this introduction of this requirement is that you have an element of accountability, and that makes probably the difference, and that you don't maybe have if you just let an algorithm do it. But I completely agree that a human decision could be also completely wrong and could be also biased.
Thank you. We need to stop because we have a third speaker. I had another remark, but I'm going to keep it for myself. The next speaker is Maria Gracia Porcedda, and she will bring us back to the first issue. Maria is linked to the University of Leeds, and she will speak on boundaries. The subtitle is Finding the Essence of the Right to the Protection of Personal Data. This looks like a very difficult inquiry. Especially if the system doesn't doesn't concur.
It's frozen. It's frozen.
Oh, is anybody handy with these machines? I'm not.
It's frozen.
This is the algorithm that is.
Exactly. It's decided. Why
it's
is it
deciding that the former speakers needed to have more time.
Thank you very much.
No, you have to. Let me see.
Yeah, no, we can.
But you can't really see the...
No, you can't see the cursor. This is the problem.
Yeah.
Maybe with the tab, as you did.
You
Oh.
Oh, okay.
Yeah,
Wait,
yeah, it's, yeah.
where is it?
Oh,
Should be-
yes, we have him.
Okay, it's
Oh,
here.
it's back.
There you go.
Okay. Maria, you have the floor.
Thank you very much for the introduction. Thank you very much for having me here. Good afternoon to everyone. So what I'm going to do in this presentation is actually quite complementary to what Maya has done, and it makes my job actually much easier because there are some concepts that have already been very nicely introduced. What I aim to do in particular is to explain what the concept of the essence is in relation to Article 8 of the Charter, why it is important, and how can we get there? How can we obtain this concept of the essence? In order to do so, first of all, I'm going to introduce the essence, but as I said, many concepts have already been nicely explained by Maya, so I'll be quite quick on this. And then I will propose a way of identifying the essence and show you the results of my inquiry. So let's go to the idea of the essence. Actually, when it comes to the essence, the ECHR, well, when it comes to data protection, the ECHR does not really, the case law of the Court of Justice, of the Strasbourg Court does not really discuss the notion of the essence, so it was only really introduced with the Charter. And as Maya has already anticipated, the Charter introduced a substantive provision on personal data protection and a horizontal provision on defining the scope and the permissible limitations of the right, which is Article 52, whereby any interference has to cope with this notion of the essence, which the explanations not very helpfully refer to as the very substance of the right. Now, the reason why the essence is fundamental, is so important, is that an interference with the essence would be impermissible. Now, what is the essence, as already been anticipated by Maya? In part, it comes from, is the best export of the German constitutional tradition. One of the most prominent constitutional lawyers that discussed the notion of the essence were Alexei. He proposed that this concept could actually help avoiding the stalemates that sometimes you reach when you apply a classic test of proportionality. And this has been worked by Scheinin, that proposed that there could be multiple core areas of right or essence. Now, how do we get there? Well, there are a number of ways, but first of all, we should start with the Court of Justice. And we could actually see two approaches, which very nicely fit into what Maya was saying earlier. Here I'm only reviewing the case law that concerns the protection of personal data. So for the wider picture, Maya's presentation is the reference. The first approach comes from what is a relatively minor and obscure case, which is called Coty. It is a case that concerns the clash between the right to the protection of personal data and intellectual property. In this case, Coty was the intellectual property holder of a perfume, and he sued a bank to obtain the banking information of someone that Coty believed was selling counterfeited copies of the perfume. The court made an analysis of the essence that was very procedural. It said that basically applying a blanket refusal to provide banking information stood against the right to information and breached both the fundamental right to an effective remedy and the intellectual property right, so that in the end, the essence of the right to intellectual property was breached. This is a procedural approach. It's a rule of law approach. The second one instead comes from a much more known case, is the Digital Rights Ireland case. Here we're talking about the clash between data protection on the one hand and the legitimate aim to public security on the other hand, as summarized as represented by the Data Retention Directive. And there the court proposed a substantive notion of the essence, which is to be understood as provisions that protect information security, meaning technical and organizational measures that adequately protect the security of data. And this was not reiterated in Tele2 Zverija, as has been noted earlier, because there the court conflates private life with the protection of personal data, but it was in opinion 115, round 150. The court uses a slightly different expression, security, confidentiality, and integrity, the information security canons, so that goes in a slightly different direction. So that gives us two approaches, substantive, procedural. Do they clash? Can they complement each other? I'll come back to this in a minute. But there's another notion that has already been raised, which is contained in Schrems. The court said that the control performed by an independent authority is an essential component of the right because it is listed in the definition of the right, which creates a big problem, because if we start considering everything which is in the definition as the essence of the right, well, we're dealing with an absolute right, and this is not actually the case. We need to define the boundaries of the right, and we need to find the essence within these boundaries. So the idea of the onion, this is a much more stylized onion, but the idea of a sphere with a core is actually more promising. And instead of starting from the essence, what we could do is to start from the nuance, or from the periphery, for instance, as Schoening called them. There have been some attempts. Friedewald et al. Identified principles, but they did so for privacy and data protection together again, so this is not really helpful. Sano attempted to identify periphery and essence in 2012, but it was very much in passing, very quick. It didn't have a proper methodology. She's actually released a book. She's published a book just in January, I think. She's publishing it now, so maybe there will be something there. Let's see what happens. So this left me with a big headache. How to find nuance, how to find the attributes. And sometimes you find the answer elsewhere. And in fact, I found it in the work of the commissioner of the Office of the High Commissioner for Human Rights, in the work that they have been doing on indicators. There, what the office did, and their work has been endorsed by the Fundamental Rights Agency and further on by the UK counterpart of the same office, is to try and deconstruct the human rights for which they want to build an indicator, to reach what they call the attributes, the intrinsic and distinctive substantive dimensions of a right. So their idea is to reach granularity so as to obtain an indicator. But this is not what I'm interested in. What I'm interested in is a very formal methodology, which I have adopted, if you want, by analogy. And what I have done with it is basically taking the steps. So it starts with a normative framework. You have to reason on the applicable law that you want to adopt for the specific right and the case law that is relevant for it. Ideally, you should come up with 4 to 5 attributes which should be exhaustive and mutually exclusive. This can be refined through authoritative sources. And finally, perhaps we can reach the essence. So what I have done was, first of all, to identify the applicable law, and I wish we had more time because this could be a slide on which we could spend a whole session. So we start with the Lisbon Treaty, but when it comes to Article 8, I'm proposing to do something that has been hinted at by Gloria, but Gloria did not develop this in the book, so I hope that we can have a nice discussion. So looking at it, Orla Linsky, I think, also proposed this. Going through Article 52.2 of the Charter, this means getting rid of the ECHR. It's not actually getting rid of it in the sense that it still has special significance in the context of the European Union legal framework, but it means that it's no longer constricting the meaning of the right to the protection of personal data. And this has been supported somehow by the opinion of the Advocate General in Teletus Verige. It's ground 79 in particular. If the ECHR goes out of the picture for the protection of personal data in EU law, then it means, as Craig, for instance, has argued, that we should give a little bit more importance to secondary law, so long as it's very extended and so long as the court agrees that the case that secondary law represents a correct implementation of the right. When it comes to international law, I'm proposing to use the revised Convention 108 because, as the GDPR acknowledges, this represents the basis for recognizing the adequacy of third countries. Authoritative sources are very many, but for this work in particular, I relied on Bygrave and the Head. So some of you may actually be asking, what about fair information principles? Because we have actually a very broad based in fair information principles? Well, in the case of the EU legal framework, we have to work on what the court said. All elements of Article 8 are essential components, so I'm interpreting this as meaning attributes. And some of the essence can actually come from secondary law. So it means that not all fair information principles are reflected in the Article 8 formulation or in the GDPR. It also means so it actually means that there's no space for copying and pasting the fair information principles and just reusing them. We need to be a bit more, we need to do something a bit more complex here. And in any case, the attributes should be as few as possible, and the fair information principles are many and varied. On the basis of this very, very complex sort of taking on and off board, I've come up with a potential list of attributes. These are legitimate process, so some of them come from Article 8 of the Charter, some come from the Court of Justice, some come from secondary law and Convention 108. I wish we could go into details for each and every of this, but I'm only going to focus on the legitimate processing and human control. And you'll see why in a second. The legitimate processing comes from Article 2, Paragraph 2, Section 2 of that same paragraph, and it's basically putting together the notions of fairness and transparency, purpose, limitation, and lawfulness that needs to be respected when data are being processed. The reason why they are together is that fairness, purpose, limitation, and lawfulness don't really stand alone in the concept of the protection of personal data. You always have these together, and this is recognized in the principles in the GDPR. Now, this is interesting because these reflects, so these are attributes of the rule of law. They stem from the rule of law. And Bygrave said this. He said that an important part of data protection comes actually from the rule of law. It could be very interesting, though, because it also reflects the approach that the court had in Coty. So we have one reflection of this approach in the Court of Justice's case law. The other one that I wanted to focus on is oversight, which is in particular human intervention. So one of the two sides of oversight is human intervention. This comes from Article 22 GDPR, and I'm really glad that the colleagues presented the case of algorithmic decision-making earlier, because it taps exactly into that. This is not part of the principles, this is not part of the definition, but it's, in my opinion, the future of data protection. These attributes means that decisions significantly affecting an individual cannot be taken by a machine, and that a human being must be involved in the process. There could be an essence here. An essence could be identified. It's experimental. At a minimum, you have to be able to question someone, to understand what the meaning behind the reasoning of the machine was. And Bygrave, interestingly, pointed at this, but he did not recognize this as an attribute back in 2014. This attribute also nicely meets the parameters of the Court of Justice in the Digital Rights Ireland case. It's a substantive understanding of the essence. Before concluding, just one last point. Unlike Bygrave, I believe that sensitive data should not be an attribute of its own. Because this would stand against the idea that every data deserves protection irrespective of its content. Rather, sensitive data should lower the threshold of permissible interferences. So to conclude with, some of my anonymous reviewers, who I really much thank, said, well, can you actually distill an idea of the essence? And my answer is no. I think data protection is a narrative. We still have to understand whether Coty or Digital Rights Ireland will prevail, but I think that perhaps these are complementary rather than clashing notions. And the approach of the court for other rights, or the approach of the court for the essence that Maya was discussing, I think is going to be very helpful in this case. But we should not wait for the court, because the discussion on the essence is very helpful meanwhile, not just for the collision of rights or the collision between rights and legitimate interests, but also to assess the potential intrusiveness of technologies. And if you want to realize privacy by design, we need to have a discussion like this. What are the attributes? What is the essence? What it is that a technology doesn't have to go against? And if you're interested in the full story, this is actually part of my PhD thesis. I've done the same for privacy, so there's a full distinction between private life and data protection, and also how they relate to information security canons. But this is all for today, so I thank you very much for your attention, and I thank my reviewers as well. Thank you.
I think we still can take some questions, and we can applaud indeed. And I see that Gloria is already taking position. That's good.
Thank you very much. I really like the subject. I think somebody should organize a workshop or at least one panel one day. Yes. But the subject I like is, of course, not the essence, but the content of the right. The essence, I'm still skeptical. But so basically, two questions. You said we'll maybe understand this when we get rid of the European Convention on Human Rights, so we get the Human Convention out of the picture. And that's why should we just forget about the European Convention? Can we just replace it in its context and indeed not take it as an authoritative reference, but understand that they have a different perspective because they have a different basis? But the slide that actually I would like you to show again is the one with the table with the green things, because for me, what I think the court sees from time to time is the one with the table with some green thing. Yes, no, before. Yes.
This.
Yes, so my feeling is that the court sometimes does have a vision of something that is about the scope of the content of the article, and it's about independent supervision. So I don't know why here you don't put an X thing on independent control. I think the court has said many times it's a core component of Article 8, independent supervision. So is it because it doesn't say the essence that you don't think it's about the essence? But if it's a core component, can it be the essence? Thank you.
There's immediately a second.
Yes, because I have just a question which very much relates to what you have asked already. Again, coming back to my background, my idea would be that, in fact, a stripping of data protection, especially in employment context, of the privacy pedigree might be very dangerous in the sense of the possible instrumentalization of the right as such. And I would say that you can truly find the essence, for example, but again, in the employment context of the right to data protection, if you realize that the right to data protection as such is complementary to, or right to privacy is complementary to right to data protection. On the other hand, also to social rights of workers. As such, we have an integrated, the so-called integrated approach coming from the European Convention of Human Rights, which for me would be the way to grab the essence for the time being. I mean, it's fascinating, but I still don't understand what is the added value of, for me, black boxing somehow data protection, just showing what should be inside somehow, or what is the direction, how to put it inside, without saying what it is, as such. So a pretty long question, but so I hope you got my point.
Thank you very much for both. Now, the first question by Gloria, the ECHR, partly answers also the second question. I have a problem with ECHR, and it's the fact that data are granted protection depending on the information that they carry. Very often the court is more willing to grant more protection if the information that is yielded is sensitive or not. But I think the whole point of data protection is prospective. It is, you want to protect data now because you don't know how it's going to be used tomorrow and how it's going to be merged with other databases. And this is what I see is a very important element of data protection that the Convention on Human Rights does not recognize by giving different importance to different information carried by the data. Now, there's something more fundamental about the ECHR. Well, there's something more fundamental. Not being linked to the ECHR gives a little bit more freedom internally to also decide to take a more evolutive approach towards the right, because the Court of Strasbourg is a bit slow and I think it makes a lot of sense in the context of the Charter, the way how the Charter is written. Article 52, Article 8 of the Charter does not fall in the list of Article 52.3. It comes from originally in the treaty, Article 286 of the Amsterdam Treaty, something that you actually say very nicely in your book. And as a result, there is room for taking that route. Now, this doesn't mean that the ECHR is no longer important, and in fact, it will be through Convention 108, because the ECHR, well, the Strasbourg Court will still interpret Convention 108, and that will be important in. And there's the old question of whether we will actually exceed the convention, the ECHR at some point. Question mark. But second question, I agree with you. I mean, we don't want to create silos, we want to create dialogue. My problem again is really that the case law of the Court of Strasbourg has this limitation on the contents of data, which I think really goes against the idea of how data protection is being developed in EU law. When it comes to the table, I think you're right. There should be an X there. And so this is an editorial mistake, because it is part of Article 8 and indeed the third paragraph. So thank you, and I'll correct that.
I think Gloria is right. We could spend the whole seminar on that topic. I hope one of you will organize it. In the meanwhile, I would like to thank the speakers for this. I would like to thank the speakers for this extremely interesting session. So give them a good applause before. Thanks to the public as well. And then I have a small announcement. There are drinks, if we are quick enough, in Les Halles. And at 7 o'clock, there is the opening of an exhibition, Watching You, Watching Me, a photographic response to surveillance. It evokes both Sting and ABBA, but anyway, it is in Le Palais des Beaux-Arts. So if you want to go there, please go, and thanks for your presence and your engagement.